We have to talk about the Supreme Court immunity decision involving Donald Trump. We also have to discuss the fact that prior United States presidents have done all sorts of sketchy things, such as, like, for example, steal physical gold from Americans. And yet none of them were ever indicted for crimes. Let's talk about this Trump immunity case. This is a huge win for President Trump. Let me explain to you all the different ways this benefits Donald Trump, both in federal court and state court and beyond. We have to break it down to get geeky, because to be the smartest person in the room in the Second Amendment, you also have to understand other constitutional issues, because it all works together to protect our freedoms. Stay tuned. We're going to talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 terrorist attacks by Hamas teach Americans about the right to bear arms. We should always be learning the lessons of the downside to having disarmed people and the upsides and the benefits associated with armed citizens, which we have here in the United States, thank God. All right, folks, so here's the story. The Donald Trump immunity decision has come out a couple days ago, but as you know, I've been tied up with some other things, so I had to took me a couple days to get this video out, but I want you to hear it because it's important so you understand exactly what's going on here. Let me be very clear. This is a 100% huge win for Donald Trump, okay? You may like Donald Trump. You should like Donald Trump if you like the Second Amendment, as I've talked about in other videos, but nevertheless, whether you like Donald Trump or hate Donald Trump, doesn't matter. This is a big win for President Trump, because the court has basically said that this case was not properly handled by the lower courts. And because the lower courts screwed this up, did not take it seriously, did not properly analyze things in a serious way, including some of the complex constitutional questions presented. Instead, the lower courts tried to rush this case through. In a world in which, as you know, in the Second Amendment movement, cases are measured in terms of number of years is how long a bunch of our Second Amendment cases take. And yet, miraculously, the first ever criminal indictment of a president of the United States, the former president of the United States, somehow rushes through the court system all the way up to the Supreme Court at a speed that we could only hope and pray and wish we would see in the context of Second Amendment challenges to government regulations. But alas, I'll let you speculate as to why that happened in the case of Donald Trump and the deep state courts of Washington, D.C. Okay. So anyway, big win for Donald Trump. The U.S. Supreme Court came out and said that presidents have absolute immunity for activities that they engage in as part of their official conduct. Meaning if there's a specific duty or authority or power they have set forth in the U.S. Constitution. And as you know, Article 1 of the U.S. Constitution deals with congressional powers. Article 2 of the Constitution deals with the president's powers, or the executive branch. And Article 3 deals with the courts, cases and controversies, for example. We're dealing with Article 2 here, the president or executive branch's authorities. If it falls expressly within those authorities, like the ability to pardon, or the ability to defend the country, or the power to to recognize a foreign government, whatever it is, if it's expressly set forth in Article 2 of the U.S. Constitution, that is considered in the core presidential powers, and he has absolute immunity for any and all acts he undertakes within those core powers articulated by the Constitution itself. If there is something that is arguably touching fingers with his powers, he's using the bully pulpit to talk about an issue. He is discussing issues associated with enforcing federal law, whatever it is. He is entitled to a presumption that he is entitled to absolute immunity. So the first bucket here is absolute immunity, core set out in the Constitution, totally 100% immune, period, full stop. That does not mean, of course, he cannot be impeached and removed from office through the impeachment process. But in terms of being indicted and put in prison in the criminal court system, absolute immunity. And just as a reminder, the reason why all this comes up in the constitutional structure of things is we have three federal branches here, right? We have separation of powers among three branches: the executive branch, the courts, and the Congress. Three branches of government: the legislative branch, Congress; the executive branch, the president; and the courts. And of course, if you allow the courts to put a president in prison, which is what you're doing if you indict him and try him in the courts, think about it just conceptually for a moment, what you've done. You've allowed one branch of government, the court system, Article 3, the court system, the judiciary, to have the power to imprison, through the court system, another branch of government, in this case, the President of the United States. And if you look very carefully at this Trump immunity decision, they're very clear that one of the overriding concerns in all of this is the separation of powers, that you don't want one part of the government to be able to override and destroy the other part of the government through, let's say, criminal prosecution and imprisonment, because that endangers the checks and powers, or the checks and balances that our founding fathers put in place to protect our freedoms, to let the government fight amongst each other. In the process of fighting amongst themselves, they ultimately protect individual freedom of Americans. So anyway, if you let the court system put Donald Trump in prison, you're basically creating an incentive for the court system, Article 3 of the government, to penalize and punish and threaten and intimidate another branch of the government, the president. And that is what the Chief Justice John Roberts' opinion had a lot of concerns about, which is why he said that presidents have absolute immunity for their core government functions. The second category, of course, is presumed immunity. So you got absolute immunity in one bucket, presumed immunity in the second bucket, and then you have no immunity in the third bucket, which we'll get to in a minute. The presumed immunity is anything that's kind of on the line. Again, political speeches. Is he giving a political speech that really speaks to the State of the Union? If it's a State of the Union, then that's absolute immunity. But if he gives the exact same speech on the campaign trail as a political candidate, well, maybe is he speaking as the President of the United States in that context? Or is he speaking as a private citizen? What exactly is he doing? Well, what the court said is in that second bucket of presumed immunity, that if there's any doubt at all, well, we're going to assume that he's entitled to immunity, and it's absolute immunity. But that's not always true. So, for example, if he's talking to his private lawyers about a private matter, that may fall on the line that his conduct is not official. It's not part of his official duties as president. If that's the case, he can be indicted for his conduct. So again, you have absolute immunity, then you have presumed immunity, which can be rebutted with evidence and proof from, let's say, the prosecutor. And again, the court specifically says to understand whether or not a particular action that's not a core action or not necessarily an official action of the president, you have to determine the details of it. You have to look at the context of what the president was doing at the time. You got to look at the content of what he was saying, the form that it took, and the context. So again, if he's speaking at a fundraiser, trying to raise money for, let's say, the Republican National Committee, and he's saying a bunch of stuff in the context of raising money for a political party, well, that is presumed to be part of something that he has immunity for. It's presumed to be an official act of the president, but it can be rebutted. And if they could show that, look, he was really only doing this in the context of raising money for a political party, he wasn't doing it as part of his role and responsibilities as commander-in-chief, that presumption of immunity can be rebutted and overcome. And then, of course, the third category here, which seems to never make its way into the Washington Post or the New York Times editorial pages, is that if it's a purely private action, he's doing something that is purely private, and he commits a crime, then he has no immunity whatsoever. So if he's doing something in his private capacity, he goes out and commits cold-blooded murder on the streets of New York with a gun and shoots someone and kills them because he doesn't like them, doesn't like how they look, well, that's going to probably be, in all likelihood, purely private conduct, right? And there is no immunity. So, of course, the reporting on this is kind of absurd because they talk all about how he has absolute immunity but for official acts, but, of course, they ignore the fact that he has no immunity. No president has any immunity, the Supreme Court said, for purely private acts. So if if you rob a bank, there's no official conduct associated with the White House there or being the commander-in-chief. You could be indicted and tried and put in prison. No different than any other American. Now, I want to talk about some of the specific issues here and what to keep in mind. Specifically, if you look at the indictment by the anti-Trump prosecutor, Jack Smith, who was hired by DOJ to do one thing, and that was to go after Donald Trump. If you look at his indictment, which is like 114 paragraphs long, let's talk about how some of those parts of the indictment may have to be removed. So to begin with, just to be clear, what's happening now is that the Supreme Court has laid out the legal standards, which I predicted. What's absolute immunity, what's presumed immune, and what is not immune at all. 3 buckets. And they're saying, look, we're not going to decide initially what's what in this indictment. We're going to send back this legal standard, our opinion, we're going to send it back to the lower court. And it's up to the lower inferior courts to have the first crack at which allegations of Jack Smith against Donald Trump in that indictment fall into which bucket. So if there's allegations that clearly, and one of the things, for example, the Supreme Court says, if Donald Trump was having communications and conversations with the Attorney General of the United States and the Justice Department, that is core government functions. That's a core presidential conduct of enforcing federal law. As a consequence, that would be absolutely immune. Conversations associated with talking to the Department of Justice. So the reason why that's important is if in that indictment, let's say of the 114 paragraphs in the indictment against Donald Trump, 6 of those paragraphs, for the sake of argument, 6 of those paragraphs have discussions about Donald Trump's communications with Attorney General Bill Barr, or Donald Trump's communications with the Department of Justice about what's going on legally with federal law in the federal election. Those paragraphs will have to be removed from the indictment and not considered. Not only can you not indict him based upon that, you're not allowed to use those assertions against or those facts against Donald Trump. So those paragraphs, let's assume there's 6 paragraphs dealing with Trump's communications with the Department of Justice, because that's purely presidential conduct, pure presidential powers, that's absolutely immunity there for President Trump. Those paragraphs get removed from the indictment, and then the indictment has to be reread, if you will, to see if it still states a claim, if it still sets forth a crime. So that's the first thing that happens. It also indicates that to the extent that Donald Trump is having conversations with the Vice President of the United States, that is presumptively immune. It may not always be immune. There may be some, if you look at the context, maybe it's a little bit different here. But again, generally speaking, the president is allowed to have communications with his vice president as part of his presidential powers, his presidential duties. So his communications with Vice President Mike Pence are presumptively protected by this order, this opinion. So assuming that that is found to have been part of enforcing federal law, federal election law, those indictment allegations or facts saying he talked to Mike Pence, those will have to be removed from the indictment and removed from the case as well. Okay? Unless, of course, they can overcome the presumption, which is not going to be that easy. On a related note, I think the January 6th speech is going to be quite interesting because, again, here's an example where it's kind of a little bit of a line call. If Donald Trump is speaking on January 6, 2021, using the bully pulpit of the White House to say, hey, I have concerns about this election. I have concerns about the federal law enforcement here. We need to make sure this is done right. We need to be peaceful. That arguably that will be presumptively immunized. I mean, he will benefit from presumptive immunity in that context because he's acting as the president. He's given a speech. But theoretically, that could be rebutted. So if it is established that he is speaking on January 6, 2021, really as a political party leader or as a political candidate for office and not really speaking in the role of president of the United States, then arguably that speech on January 6 may not benefit from immunity. It's going to be an interesting question as to who makes that decision initially. That will be up to the lower court judge, in this case, Judge Chutkan. Now, if Judge Chutkan rules against President Trump, that will be another adverse decision in the context of the immunity fight, and I believe that would be subject to an immediate appeal. So to make a long story short here is practical matter, there is 0% chance. There is a 0% chance that the Jack Smith indictment of President Trump in D.C. will be tried before the November 2024 election. There will be a 0% chance of that occurring. There is just no way for the lower courts to do this analysis and figure this out. And then after the decision, if there's anything adverse to the criminal defendant Donald Trump, that will be appealed up to the federal courts to the Supreme Court as well. There's just not going to be enough time in a court system where cases are measured in years, unless, of course, you're in front of Judge Juan Marchand in New York State Court. So let's talk about that case and how, just for a moment, that case is being impacted by this presidential immunity decision by the Supreme Court. Now, you may have seen that Judge Marchand in the hush money case, which is really just a bookkeeping record case, stupid case, Stupid case. Never should have been brought against anybody, including Donald Trump. Just dumb. Unserious in all respects. You've heard me say that on Fox News. I'll say it again here. It's just dumb. And nevertheless, at least it got the Democrats the ability to call Donald Trump a convicted felon, which they're able to do as a political propaganda term. We'll see how that plays out in November. But the reason why you may have seen that Judge Marchand has just entered an order that says he has delayed sentencing Donald Trump from July, I think 11th, 2024 into mid-September 2024. The question is, why did he do that? Now, he did this because both sides, both the government, the district attorney of Manhattan, which is one of 3,000 counties, by the way, right? This is a county prosecutor that went after Donald Trump in New York. You hear what I just said? A county prosecutor. This would be like Prince George's County's district attorney going after, a presidential candidate. Okay, it's just absurd to think that a county prosecutor could do this. But that's all this Manhattan DA is. He's literally a county prosecutor. Okay. In the grand scheme of things, it's fine, but it's a county prosecutor. Hardly the kind of guy that should be going after the president. Nevertheless, that's what happened here. So what happened in that trial, though, is there were several bits of evidence that were brought into that case over the objection of Donald Trump's lawyers. And the basis of the objection of certain documents that were brought into that trial was that those documents or that information was protected, privileged, or part of the presidential immunity, and it should not have been allowed in because you're not allowed to use materials that is part of the immunity to prosecute someone. And because the argument goes that a lot of the evidence that was brought in against Donald Trump in that state criminal case should not have been allowed in because it was part of the president's core function as presidential powers. The fact that it was let in means that the Judge Marchand criminal case where Donald Trump was convicted, that has to be at most retried, if not just undone, because they got to retry the case, removing all the improperly admitted evidence from the case and be retried without it because the evidence that was allowed in dealing with President Trump's conduct as the commander-in-chief and statements he made as the commander-in-chief came in to be used against him, but it's not allowed to be used against him because that was part of what would fall within the scope of his immunity protections. And there's no doubt that some of the documents involving presidential ethics, materials, and statements Donald Trump made as president would be within his core power of being president, I believe, and that's why Judge Marchand has delayed the sentencing of Donald Trump until September so he can look at the briefs coming in from both parties as to whether or not part of the case in chief against Donald Trump needs to be expunged, eliminated, and then the question will be whether or not they have to redo the whole case. Do they make it an acquittal? How do they handle that situation where evidence that was not allowed in under the law was allowed in and the jury was allowed to consider it? So that's very important. And the last point I want to make is a great summary here by the columnist and attorney Ann Coulter, where she just makes an observation of all the Democratic presidents have done things that are very clearly borderline criminal, if not criminal, but these are the things that seem to be getting ignored by the mainstream media. And I thought it was such a nice list by Ann Coulter that I wanted to put it on the screen so you could see the things that the Democratic presidents have done over the last many decades that arguably could have got them indicted, and now they would be protected by this Supreme Court decision of immunity. So it's not just benefiting Republican presidents, it can easily benefit Democratic presidents. Let's look at this list that Ann Coulter came up with here. Ann Coulter writes, quote, "There's no mention of presidents interning the Japanese, Franklin Delano Roosevelt. There's no mention of expropriating gold from U.S. citizens, another specialty of Franklin Delano Roosevelt. No mention of seizing the steel mills, that's Harry Truman, Democrat. No mention of using the CIA to spy on a rival's political campaign and the FBI to bug an opponent's campaign plane, that's Lyndon Baines Johnson, a Democrat. No reference to bombing a foreign country on the eve of his scheduled impeachment, that's Bill Clinton, or flinging open the border in direct violation of federal law, both Barack Obama and, of course, Joe Biden." Again, a great list from Ann Coulter, and I think it just illustrates the point that some of the hair-on-fire language we're seeing about the U.S. Supreme Court is just upsetness by people that either don't know what they're talking about or by people that know what they're talking about and they don't care because they're not really journalists. They're really just political propagandists who basically take DNC, Democratic National Talking Points, and rewrite them. And they're nothing more than rewriters of press releases of the Democrats, in my view. That's what a lot of journalism is in the United States, which is why you can't take a lot of it very seriously. And I certainly do not. I take a lot of their statements with a grain of salt. Of course, the journalists were totally on top of Joe Biden's cognitive issues. They definitely did a lot of reporting on that over the last year or two, didn't they? Ha 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 ha. Anyway, that's where you are, folks. So I wanted to bring this information to you about the Trump immunity decision because it's very important that you be able to talk about this. We'll talk more about this down the road, as well as a lot of other Second Amendment related news. And again, don't forget to follow me here. Make sure you follow me on X at 4boxes Diner. Make sure you check out my book, Israel Disarmed. And don't forget, of course, that's on Amazon. And feel free to leave a review if you've already read the book. And we'll see you again soon here at the 4boxes Diner.
Orders up. Table 2A.